Oh, snap. Welcome back to the Mystery Project. My name's Patrick. If you're new, YouTube, hit the subscribe button because we do true crime live streams. We do body cam reactions and live streams. We talk about all kinds of stuff over here. So hit the subscribe button. Hit the thumbs up button for me, especially if you like the video because I appreciate it. It helps the channel out so much. We're also live on TikTok. Shout out to TikTok. What's up, everybody? And let's talk about some Bryan Kohberger action. I'm going to shrink myself down. And this says Bryan Kohberger loses big as new evidence is revealed. Oh, hell. What'd they find now? Some more DNA? I don't know. Let's go.
When emotional evidence or picture evidence comes in that a neurotypical person will react to, he will not react. And that is only because he has a physical disability.
After hearing about Bryan Kohberger's autism...
Hold on. She's trying to say that if they show a picture of something, that most people would be like, ugh, it would like get a reaction. He's not going to. And she's saying like they shouldn't show any pictures or videos of anything because of that.
How dare you?
That's crazy.
And OCD, prosecutors in his death penalty case want their own experts to evaluate him, but it's been kept under wraps until now. I take a look at what prosecutors wanted and what they're getting, along with a big decision on whether Kohberger's family will be allowed in court during the trial and how serial killer Ted Bundy could come into play. Welcome to Crime Fix. I'm Anjanette Levy. There are a few new developments in Bryan Kohberger's death penalty case. Some are coming out of court, while others are coming from new reporting from an episode of Dateline NBC airing this week. More on that later. For a while there, we were getting a really good look at what was going on in Kohberger's case in Idaho because Judge Hippler told both sides they needed to be more careful about what they filed under seal. Then earlier this week, Judge Hippler held a sealed, closed hearing where the public wasn't allowed in. It was all over the prosecution asking for a mental evaluation of Bryan Kohberger ahead of his trial. Jury selection in the quadruple murder trial is scheduled to begin in less than 3 months. It's a death penalty case, and that makes it more involved, more complex, and there will be a lot of experts testifying about.
Right. By the way, TikTok overlords, entertainment and educational purposes only. This is a true crime channel. Entertainment, educational purposes only. I know the TikTok overlords get mad as hell when they hear certain words. TikTok overlords, entertainment, educational purposes only. When there's bound to be some manual review of this. That's why I stopped going live on TikTok for a long time, y'all. They upset me very mucho. All right, let's keep going. Sorry.
About everything from DNA and his car make and model to cell phone evidence. But now prosecutors have asked Judge Hippler to allow their own expert to perform a mental evaluation on Bryan Kohberger as they prepare for a possible penalty phase in the trial. Bryan Kohberger's lawyers have said in recent hearings he maintains his innocence in the murders of Maddie Mogan, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin in November of 2022.
Why would they be worried about the penalty phase if he's so convinced that he's innocent? Like, if I knew for sure I was 100% innocent with something, I wouldn't be worried about the penalty phase because I'd be like, there's no way it's going to even get that far.
Those 4 University of Idaho students were brutally stabbed to death in a home near campus in Moscow. Investigators said that they linked Kohberger to the crime after finding a single male DNA profile on the snap, this part of the snap of a K-bar knife sheath that was left at the crime scene. According to Judge Hippler, the defense essentially has conceded that prosecutors should be allowed to have an expert evaluate Kohberger since they had their own experts do the same. But the two sides disagreed on ground rules, like whether the defense attorneys should be allowed to be there for the evaluation and whether Kohberger should be tested for personality disorders. All of this is coming after Kohberger's lawyers have tried unsuccessfully to get the death penalty stricken as a possible punishment for Kohberger if he's convicted. Most recently, they argued he has autism spectrum disorder and that should make him ineligible for the death penalty. Here was Kohberger's attorney, Ann Taylor, at a hearing last month talking about why Bryan Kohberger's autism spectrum diagnosis.
Man, Ann Taylor is looking crazy as hell right there. She looks like she's looking crazy right there. I mean, I don't know her, no offense, but like she looks like an extra from like Hocus Pocus or something.
Shouldn't be used against him.
But Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And
how dare you?
They have unkind things to say about him. Yeah, no, you don't say. Oh, man. Oh, no. Not the man that's arrested and suspected, charged with, and now on trial, about to be on trial for 4 college students. People have unkind things to say about him. Oh no, cry me a river. That is crazy as hell. Maybe somebody should have had some unkind things to say to him to where he wouldn't have done something like this if he did it. We'll find out. Ooh, man, that is a crazy thing to say.
a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful
What does any of this have to do with anything? Do you know what I mean? The jury is going to come in and look at the facts of the case that are presented to them. All right? And if after all the facts are presented, they come to the conclusion that beyond a reasonable doubt, beyond a shadow of a doubt, this man did it. It doesn't matter if his IQ is 150 or room temperature. It doesn't matter if he's on the spectrum or not. If the facts line up and say he did it, then he did it.
comments, those mean.
They're reaching for such crazy stuff nowadays. Like, there's just so many people that just, it's like, oh my God, this, that, blah, oh, da, da, da. It's like, no. He might have a mental disability. No shit. He is alleged to have taken 4 people's lives. You think normal people with rational, non-mental, you think those, like, they're going to do something like that? Oh my God. Of course, every single one that has ever been put on trial, that has been convicted and put in jail, has got to have something wrong. That's why they're there. How on earth would that be a defense?
Comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may no, that's not. That's his view of women and goes to motive, etc., and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem. Your Honor, if the state and
Do you want,
I want to be
me to weigh in
clear.
and say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
For their part, prosecutors said they have no intention of using
I don't know.
autism against Bryan Kohberger.
The state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism.
Kohberger's request to strike the death penalty because of autism has failed. So let's say Kohberger is ultimately convicted of murdering the 4 students. When it comes to the penalty phase of the trial, his lawyers will pull out all of the stops to present mitigating evidence to the jury, hoping they will spare his life.
The initial expert report that was provided in the fact phase of Dr. Orr and Dr. Ryan, and Dr. Lewine's report was attached to our reply for the basis of substantiating that our argument is that this is a neurological, biological disability. We are not taking the position that this is a mental condition. Clearly in the...
Dear God, do you know how horrible it must feel for him to be sitting there going, my defense is only talking about taking the D penalty off the table. That's my only that's the only defense my defense has right now. Well, if we get there, we shouldn't, him because of all these things.
How dare you!
That is crazy. He's got to be sitting there like, well, at this point, might as well take a plea deal.
The state of Idaho, one of the guiding cases.
Yeah, there you go. There you go. Why not do that? Why not? You don't want the penalty. Take a plea. Take a plea for life in prison. There you go. Done. Oh, it means that much to you? Take a plea deal.
Is regarding mental condition.
Is there an inconsistency there? Because it seems like on the one hand, you're arguing that his autism spectrum condition shouldn't be used as an aggravator, as a mental health condition. I mean, yeah, it shouldn't be used as an aggravator, as a mental health condition. On the other hand, you're arguing his non-mental health condition under 207.
So I think that it's really important. I know that you grouped these two arguments together. This issue that I'm talking about right now has to do with the fact phase, the guilt phase of the trial. Everything related to aggravator is at a different phase.
Are you taking the position that it's a mental health condition as it relates to aggravation and not a mental health condition as it relates to guilt phase?
I don't think we've said anything about it being a mental condition as it falls under.
You had it right in the very, very beginning. I don't think we've said anything. Just stop right there.
18207.
No,
we're talking about this being a neurological, biological disability.
Now, when Kohberger's lawyers...
If they're putting this much emphasis on this, just imagine how thin the defense really is. Do you know what I mean? Like, this is razor thin. If they have to be like, well, the neurological this and that, what?
talk about 18-207, they're talking about a statute in Idaho that says mental conditions cannot be used as a defense to any crimes. But that doesn't mean Kohberger's lawyers won't use his autism diagnosis as mitigating evidence against a possible death sentence. Here's attorney Alyssa Masseth talking about that possibility.
Imagine if you do not let this testimony in phase 1 of the trial and the jury convicts Mr. Kohberger. How angry and misled might those jurors feel when they learn in mitigation where without a doubt this comes in at mitigation, that he has this disorder and it has them second guessing themselves. We must avoid that possibility.
Now, Kohberger's lawyers haven't just said he has autism. They've also said he has obsessive compulsive disorder, and they've suggested he has coordination issues that fall under another disorder that would make it unlikely he could have carried out 4 murders in a matter of minutes.
In response to Your Honor's question about, or observation that there's no evidence from an expert here that the defendant.
Did the defense just say that he couldn't have done this because he's clumsy?
What? What the fuck?
Your Honor, no. Our client, he can barely walk. I mean, there's no way you could carry out any of these things. He is too clumsy.
Is incapable of committing these crimes. The response from the defendant was, well, yeah, that's right, which is exactly our concern, because the defendant in his filings took what little was in the expert disclosures and then stretched it out to this conclusion that the defendant is incapable of committing the crimes when the experts don't say that. I mean, they are essentially creating an opinion that doesn't exist. So, Your Honor, our request stands. Certainly the evidence that's being proffered about his demeanor is not relevant. It shouldn't be admitted. And if there's an issue that comes up about the defendant on the stand and his appearance there, I think we can address that as it comes up. Likewise, if the state opens the door to questions about the defendant's behaviors, which we are not intending to do, we can address the issue at that time. So we'd ask the court to defer any kind of ruling on those hypothetical situations.
The OCD that the defense claims Kohberger has could possibly become an issue at trial.
As for issues that relate to state of mind, it does depend on what the state offers. We agree with the state on that aspect. If they stay away from the issues regarding cleanliness and a missing shower curtain and speed in which the crime occurred, and wearing gloves or showing him at various places wearing gloves with some sort of negative attribute that he is doing that to hide DNA as opposed to what's going on with his autism, it's our position that that opens up the door to the opinions that the experts have expressed.
Now, police have said that Kohberger was wearing...
What in the hell? Man, if the dude is wearing gloves everywhere, he's probably doing it because of, well, there's 2 reasons. 1, he doesn't want any of his DNA anywhere. And 2, he doesn't want anybody else's DNA on him. Like, come on.
Plastic gloves, kind of like these, and separating his trash into baggies when he was arrested at his parents'.
Yeah. Has he ever done that before? Are they going to really testify that he separates his trash, all of his trash, into little baggies with plastic gloves and puts them in the neighbor's trash? That's what you do?
What?
That is crazy as hell. By the way, TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, I'm live every night. We talk about all kinds of different cases. Hit the follow button. Also, come over to YouTube because we're live on YouTube right now. And that's where you can see all of the videos. So we're live right now and you can actually watch the video there. TikTok won't let me play it, but you can see it over here on YouTube, The Mystery Project. Y'all, type it in the chat. Type it in the chat. You mean you don't do that? Exactly, right? Holy hell.
Home in Pennsylvania.
The only thing I separate into little plastic bags is chicken. Get that big pack of chicken separated out. You know, you get the big pack of ground beef. You separate it out, put it in the freezer. That's about it. And I don't wear gloves doing that either. Sounds crazy as hell.
Defense says
that is nuts, man. Life is hard, but it is harder when you're stupid.
that was because Kohberger has OCD. But back to the autism. Prosecutors indicated they will argue against Kohberger's autism being a mitigating factor for the death penalty if the jury finds him guilty.
We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination.
So with all of these
Yeah, it's chicken and beef. It's not human. Exactly.
doctors evaluating Bryan Kohberger for the defense and diagnosing him with autism, obsessive compulsive disorder, and developmental coordination disorder, eating disorders, and a history of substance abuse, the state filed to conduct its own evaluation. On April 25th, the state filed a motion for exam pursuant to Idaho Code 18-207. The motion also asked for an extension of time to complete penalty phase rebuttal disclosures. The evaluation by the state will be used to rebut whatever the defense presents in a possible penalty phase if Kohberger is convicted. The defense filed an objection to a lengthy extension of time for the evaluation. Now, after Monday's sealed hearing, Judge Hippler ruled the state's experts should be allowed to evaluate Bryan Kohberger within 7 to 10 days. Hippler wrote, "The court will allow counsel for both sides to watch the examination through a one-way video feed or some similar method that prohibits them from being seen or heard during the examination. Under no circumstances will counsel be able to interrupt the examination." Hippler is only giving prosecutors a brief extension of time to file their expert opinion because the expert they had initially retained withdrew from the case over disagreements with prosecutors about counsel being present and personality testing. The state's expert will not be able to evaluate Bryan Kohberger for personality disorders. Hippler wrote in a footnote, "One of defendant's forensic psychiatrists, Dr. Eileen Ryan, concluded in her expert report that defendant does not have a childhood history of behavior that is consistent with conduct disorder or antisocial personality disorder in adulthood, nor does he meet criteria for antisocial personality disorder." Antisocial person.
Yeah, that's a really nice way of saying you're just a dick. You're just a really mean, horrible, crappy person that no one wants to be around. That is crazy. Yo, imagine going to the psychiatrist and they say this.
Or antisocial personality disorder in adulthood, nor does he meet criteria for antisocial personality disorder. Antisocial personality.
You don't have any kind of disorders that make you not want to be around people. People just don't want to be around you, period.
Disorder used to be called psychopathy. Since Kohberger wasn't evaluated for personality disorders by his
follow button if you're new here.
Experts, Hippler said there's nothing for prosecutors to rebut on that front. And Hippler said letting prosecutors go down that road with Kohberger could possibly violate his Fifth Amendment rights and just open up a big can of worms.
I want to bring in somebody who has prosecuted death penalty cases. He is Mark Weaver. He's also a former Deputy Assistant Attorney General out of the state of Ohio. So, Mark, we have a sealed motion here by the prosecution in Bryan Kohberger's case. And they're saying, we want a mental evaluation of Bryan Kohberger. And they kind of mentioned that they might ask for this in last month's hearing. And it seems like this is tied to the possible penalty phase from what we're seeing. We of course, don't have the motion because it's sealed. But is that what the feeling you're getting just from reading the case summary page?
First, let me just say that very few things should be sealed in court. There seems to be a lot of ceiling in this case. I am certainly aware of the need for a judge to balance the Sixth Amendment right of the defendant have to fair trial with the First Amendment right of journalists such as yourself to be able to cover this case. It just seems like there's a little heavy hand on the ceiling, FYI, but let's talk about it. We can't peer into it because it's sealed, but it's important to remember that we have two phases in every death penalty case. We have the guilt or innocence phase, and then we have the penalty phase. And the rules for the penalty phase are much more wide open. Many more things come in as evidence during the penalty phase. So it's a good guess that what these mental experts who are going to examine the defendant have to say is more likely to be relevant in the second phase, the penalty phase, than it is the guilt or innocence phase.
Right. And I want to touch on that first point you raised about the ceiling. Judge Hippler, a month or two ago, a couple months ago, had said enough with the sealing. You can quit filing everything under seal. You can redact things. It should not be the norm. But now we're back to filing this stuff under seal. Why do you think that is? Because the judge had basically told both sides to knock it off, to redact things if possible. Now we've got...
Who knows? That is crazy, though. Allie, we're watching Law and Crime, talking about Bryan Kohberger and new evidence that is, not looking good for him.
This kind of super secret motion about asking for this mental health evaluation when this has already been kind of discussed in open court.
Yeah, it's odd. I have represented judges who've sealed things before. I litigated a state Supreme Court case for a judge who sealed the outcome of a particular high-profile case. So I understand the need for it, but there is a countervailing need of openness in courts. We don't live in a closed court society. Some countries have secret courts. America doesn't. We have open courts. So I can only guess that there's some sort of substantive information in there that if they came out could change the jury pool one way or the other towards this defendant, and judges are supposed to try to stop that from happening. Having said that, it's a pretty high standard to meet.
Mm-hmm. So let's talk now about the statute they keep citing with this. It's 18-207. And in the state of Idaho, you cannot use, a mental health issue as a defense. And the defense is saying we're not trying to do that in this case. But they have tried to say that he has this neurobiological issue.
We're not trying to use it as a defense, but, you probably should... we're still his defense team bringing it up.
Autism spectrum disorder. They've also said he has obsessive compulsive disorder and this, other developmental coordination disorder.
That's crazy. That's like saying, I'm going to go to McDonald's, but I'm only going to order a glass of water.
Said all of these things. So,
they can keep their chicken nuggets and quarter pounder with cheese. I'm just going to drink a glass of water.
They are going to now, because the judge has said, they can't tell the jury in the guilt and innocence phase that he has autism spectrum disorder to explain his demeanor and his flat affect and stuff like that. But they will be presenting that in a possible penalty phase if he's convicted as mitigating evidence. They will be presenting that information. So are we to assume from the state filing a motion seeking an evaluation of Bryan Kohberger that they want to somehow be able to counter that with the defense, because they also want an extension of time to file their penalty phase rebuttal experts. So are they going to have their own expert, if the judge approves it, because the defense is objecting to this, evaluate Bryan Kohberger?
Well, imagine that.
And come up with their own evaluation about what...
Not the defense objecting to everything.
Whether or not he has level 1, the highest functioning form of autism, level 1, autism spectrum disorder.
This is rich. Imagine the defense counsel saying, we want our expert to examine the defendant and see whether he has mental issues, but we don't want the state to have that as well. That's a little crazy. It doesn't seem right to me. It seems like if one side wants to have an expert, the other side could have an expert. We call this the battle of the experts in law. And it's very common in civil cases, also in criminal cases. I've had my share of expert witnesses in the criminal prosecutions I've done. So it's very common for each side to have experts and exchange reports and offer whatever help they can to the jury to understand the issues of the case. With respect to the on the spectrum question, autism, the judge said that might come in if Kohberger takes the stand.
Sure.
And maybe the lawyers need to explain why he acted a certain way, why he acted a certain way on the witness stand. I think where the judge said you can't do is try to use it as a way to explain how he might react in court while he's sitting at the defense table. That's really just a backdoor way to try to slip into some form of he's not really culpable because he has autism. They made a similar case about why his mental social skills might be something that needs to be brought in. When they even
y'all, tell me what you think. Starr is guilty. Hart is not guilty.
Tried to use this as a defense against the death penalty, and the judge struck that down as well. I think the most likely use of all of this is in the penalty phase, where the rules are much more relaxed and all sorts of things can come in as mitigating evidence against the use of the death penalty.
How unlikely, and I know you practice in Ohio, but this is a death penalty case. And so how unlikely or likely is it that if the defense has all of these experts with reports and they've met with Bryan Kohberger, they've evaluated him, they say, oh, look, we believe, one of their experts said, we believe that he knows what's going on. He understands what's going on. Yes, he has autism, but he, has an IQ of 119, things of that nature. The defense has tried to say they continue to monitor his competency. It sounds like he can be difficult to deal with. He sees things in a very black and white way. He doesn't see
Imagine that.
Things in shades of gray. They've basically said it's hard for them to deal with him. How likely is it or unlikely is it that the judge is going to say yes to the state or no to the state, having their own expert evaluate him? I mean, is the judge going to say the state has to be allowed to have a psychiatrist or psychologist of their choosing?
It looks like overwhelming said guilty. True crime with Sheila. What are you doing? Long time no see.
Meet with him to assess whether or not they believe he has autism or OCD or all of these other things.
We start from the premise that people who've been arrested for violent felonies tend to have odd, troublesome, or disturbing personalities. Not all of them, just most of them. I prosecuted the child rape case just last week where the defendant originally told his lawyer he was going to take the stand, and then just as this lawyer was about to call him, he said he wasn't. You can see the
grape soda, grapes, TikTok overlords, entertainment, educational purposes only.
Frustration on the lawyer's face. So defendants can be difficult to work with if you're a defense lawyer. I understand that could be happening here. That's not a defense, and that doesn't mean you're not culpable for the crime.
Why would you be a defense attorney if you can't deal with bad people? Do you know what I mean? There's a reason why they got charged with the crime. You know what I mean? Why? Maybe some of them are, some of them might be innocent, but I mean, come on. Why would you be a defense attorney if you don't want to defend people? Come on.
This means they tend to be difficult. And I have some empathy for the defense counsel who have to deal with that. But your larger question about whether or not this expert will be allowed, there's two different kinds of experts in a criminal trial. One is somebody who examines a set of facts and then offers an opinion. The other one is somebody who actually examines the defendant in this case, which is unusual. And so allowing someone to have access to DNA samples so both experts can look at it, that's rather common. Having access to the defendant himself, who has a Fifth Amendment privilege against self-incrimination. So having the government's expert is a little different. I do think the judge is going to grant it just out of comedy, just fairness. But it is different to have the state's agent who presumably is going to tell.
This guy needs to be. Somebody needs to ask him why he says defend ant.
Tell the state everything.
Why are you putting the emphasis on the wrong syllable?
he or she learns in that interview to interview a defendant who has the Fifth Amendment right to against self-incrimination.
Yeah, and I was wondering about that. Like that could be tricky. And so would the defense attorney be present for that meeting, or at least maybe on the other side of the glass or something like that?
Yeah, that would be up to the judge. It's also possible that the judge might order a filter team between the expert and the prosecutors. A filter team is an outside, typically lawyer, not always, but outside lawyer who's not involved with the state, who would filter out anything that might be something that's attorney-client privilege that's learned, so that whatever the expert tells the prosecution is something that relates to mental health and not to information that the defendant gave up as part of the interview that might be incriminatory.
Now I'm going to ask you to really speculate, because the state filed for this mental evaluation back on April 25th. The defense then filed an objection to it, and then the state filed a response. And then all of a sudden,
hey, Carol,
a sealed hearing, a closed hearing, which is really rare in criminal cases. I don't think people understand how rare it is. A sealed hearing pops up on the docket for Monday, May 5th. And it was going to be a remote hearing, sealed to the public. Nobody's allowed in. And is this probably related to this issue?
Perhaps. So the notion that the filings were sealed suggests that the closed hearing might be related. But I want to echo what you just said. A lot of people who watch Law and Crime know that cameras are not always allowed in courtrooms. Certainly in federal courts, that's true. And in many state courts, judges don't let them in. And that's frustrating, but that's still an open court. If you wanted to go to that courthouse and wait in line and sit in the gallery, you'd be allowed to. The public is in there. But actually saying nobody from the public can be in the hearing, we see this in juvenile cases routinely because of the nature of juveniles. But it's almost never done in an adult felony case. And the judge must have a very strong reason for doing it. We don't know what it is, but it's troublesome that a judge would shut down what should be an open court hearing.
Yeah, especially when he's been very open about everything and sent something out telling the parties not to seal things. So it's
literally the judge said, stop doing that. And then he did like something that's that crazy. Whoa. Carol, thank you, Desiree. Thank you.
Been interesting to watch. Our next proceeding in this case is on April 15th, a pretrial conference. We believe that will be open to the public, and we are hoping it will be. So it'll be interesting to see what comes of that. Even the court minutes from that sealed hearing the other day, Mark, are sealed. So it would be nice to know just a little bit of information about what happened there.
Yeah, May 15th should be an interesting time to see what the lawyers say. Maybe they refer back to what happened in the other hearing. I will say this. I want to give a little credit to judges around the country. The death penalty cases are the most difficult cases they hear.
Sure.
And everything gets scrutinized on appeal. Most of my death penalty experience has been on the appellate side. When I was the Deputy Attorney General of Ohio, I worked on numerous appellate issues surrounding death penalty cases. And I can tell you, they get scrutinized at the state level. They get scrutinized at the federal level in writs of habeas corpus litigation. And so judges are being extremely cautious to do nothing to disturb the case so that it won't be overturned on appeal.
Yeah. And we know there's been a major spotlight on this case. I mean, that it's been intense, the media coverage. We get it.
No joke. By the way, TikTok, hit the follow button if you're new here. My name is Patrick. If you like true crime, I'm live every night. YouTube, same thing. Y'all, we're live on YouTube. The Mystery Project is the name of the YouTube channel. Come on over, subscribe. Y'all hit the like button. Let's get 50 likes on YouTube.
But, it doesn't mean things should be shut down. Mark Weaver, thank you so much. Appreciate it as always.
Good to be with you again.
Now, remember when prosecutors wanted Kohberger's family excluded from the courtroom until after
Oh, yeah, I do remember this.
Those family members had testified? Judge Hippler says that's not happening. Hippler wrote, "The scope of the family members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. Further, the family members were previously interviewed regarding the matters on which they will be questioned at trial. These prior recordings serve to protect against any attempt by the family members to mold their testimony based on how others testify before them. In addition, the trial publicity is such The defendant's family members are likely aware of what the testimony and evidence will be in the state's case in chief. Thus, exclusion pending their testimony will not necessarily prevent them from confirming their testimony. Finally, the state has indicated it would prefer that the family members remain in the courtroom and be called when the state sees fit rather than calling them as out-of-order witnesses. So Kohberger's family will be allowed in the courtroom throughout the trial. And this week, Dateline NBC has a new episode out on the Idaho case, and they're reporting that Kohberger had searched serial killer Ted Bundy on Google.
Oh, hell.
Bundy murdered sorority sisters in Florida, but had once attended college in Washington State. Dateline is also reporting that Kohberger has photos.
Yo, we're going to talk about that too. I can't do it on TikTok because TikTok is already mad as hell at this live stream. So we're going to end the TikTok here in just a second. Y'all come over to YouTube, The Mystery Project on YouTube. That's where we're going to dive into a little bit of this.
Those of female students from Washington State University and Idaho State on his phone, and that some of those women were actually friends with some of the victims from King Road. In court documents, Judge Hippler has written that experts found no digital connection between Kohberger and the victims. So stay tuned.
Oh, snap. What? Y'all, I'm telling you right now, hit the follow button over here on TikTok, but come over to YouTube right now. We're about to dive into a little bit of this. Yeah, it came over from TikTok. Exactly. Type it in the chat on YouTube when you come over too. Say, came from TikTok. Y'all, The Mystery Project. The Mystery Project. Do it right now. Come on, I'll see you guys over there. Boom. We're off of TikTok. Good. Now I can speak a little bit more freely. But y'all, check it out. Check it out. Oh my goodness. Where is this at? Where is this at? Look at this. Looks like Bryan Kohberger had a lot of pics of local college girls on his phone, including girls from the University of Idaho and very close friends of the victims, the murder victims. Color me shocked that Ann Taylor was inaccurate about absolutely no connection. Mm-hmm. Mm-hmm. Look, is that one of the pictures? New evidence for Bryan Kohberger has been revealed by Dateline. Dozens of photos of Kohberger phone, including the Idaho 4 victims' friends, new interviews, searches for Ted Bundy. Oh, no. Dateline will cover Bryan Kohberger, Idaho 4 case Friday. Here's a tidbit. They cited police documents reports Bryan Kohberger searched online for the serial killer Ted Bundy, both before and after.
How dare you!
Y'all, after. Before is one thing, right? Before is like, okay. Look, here from TikTok. Thanks, y'all. Make sure you hit the subscribe button. Hit the thumbs up, too. Let's get 50 likes. Everybody watching, hit the little thumbs up button for me. But, y'all, before and after? That is crazy. Do you know what I mean? Like, that's pretty crazy right there. Let me move this stuff over a little bit. Let's do one of these. Bam. He also searched for what? Yo, that is crazy right there. That is crazy. What is this? New security footage shows Bryan Kohberger at a pool party and on King Road. What? Do we know about this?
New security footage showing a car that is supposed to be Bryan Kohberger turning around and going up and down King Road on November 13th, 2022, has been released in the Dateline trailer. They have also released some of the security footage from the pool party that Bryan attended in Moscow.
What?
If you want to watch this episode with me, I'll be streaming live on Kick The link is in the description of this video. To see you then.
No way. Is he in there? Where is he? Yo, I got like a deja vu moment. Where is he? Is that him right there? No. Why are you going to put it in slow motion to get us to watch the whole thing and then not even show it? Oh, that's got to be him right there, huh? Is that him? Oh, come on. Come on.
Moved and he started chatting with this guy, and he had told me that he had just moved and he was starting his PhD.
Holly had that in common with Bryan Kohberger. She'd also moved away from home to work on a graduate degree, hers in plant science.
I definitely felt a little obligated to chat with him because to me he seemed a little awkward, kind of like you might expect for a PhD student who didn't know anyone at the party and was maybe trying his best to kind of get out there and be social and make friends.
Holly told Bryan about a hiking group she was part of, and then she did something that still makes her shiver a little.
He had put his number into my phone, and then I had texted him my name.
It was the very next day, the day after the pool party, when Holly's cell phone buzzed. A message from Bryan Kohberger.
The wording of the text as I look back on it is kind of peculiar.
Here it is, the actual text sent July 10th, 2022 at 1:19 p.m. Quote, "Hey, I'm pretty sure we spoke about hiking trips yesterday. I really enjoy that activity, so please let me know. Thanks."
It was almost overly formal. I really enjoy that activity, so, can you follow up with me about that?
How dare you?
What the hell? You look so different in a little box, right? I know. Yeah. Well, you know how it is on YouTube. That is crazy right there. Didn't know any of that. There seems to be a shocking number of people who believe Bryan Kohberger isn't. Of course, if he is innocent until proven guilty, the case against him looks compelling. New court filings. Is that the newest stuff going on? I want to see this again. Oh, that's not even a video. They tricked me. They tricked me.
Security footage showing a car that is supposed to be
what?
Bryan Kohberger.
Is that a car? How did they say that? I mean, it looks like ET phoning home right there. It's all
new security footage showing a car that is supposed to be Bryan Kohberger turning around and going up and down King Road.
I mean, it kind of looks like a white car right there.
On November 13th, 2022, has been released in the Dateline trailer. They have also released...
I don't know. Y'all leave a comment. Let me know what you think. Is he guilty? Is he not guilty? Are you excited for this trial? I am. I'm probably going to be streaming the whole dang thing. That was like the first TikTok video I ever did, was talking about this dude. And that's when I was like, oh, I guess I'm true crime on TikTok. It got like 5.5 million views. Dang. All right, y'all. I'll see you guys tomorrow. Make sure you subscribe if you're new. My name's Patrick.